But today I wanted to just talk to you briefly about search and seizure issues. Now you guys are, I feel like this is like preaching to the choir here because you all probably know as much as I do about searches and seizures. You all are a very educated crowd. But I get a lot of normal people who call me and who don't really know Texas laws on searches and seizures. And there's a lot of misconceptions out there. So while this may be elementary to some of you guys, I just want to go through the rules just so you understand them and so you know what's going on in Texas. And then we're going to talk about cars, we're going to talk about searches and seizures related to your house, and we're going to talk about some new laws that are coming out with searches and seizures of cell phones and what information you may keep in your cell phones and how that can lead to additional arrests and charges against you. So getting started here, I'm going to talk about some standards of proof, and it's a lot of legalese. If you've ever been involved with the law before, you've probably heard some of these, but let's just briefly cover them. This is a percentage of proof that an officer or a jury has to have in a certain situation. So most of you have heard of beyond a reasonable doubt. Beyond a reasonable doubt is the hardest burden of proof that must be had to get you convicted. Basically, a jury must believe you're guilty beyond a reasonable doubt before they can convict you of an offense. It's not 100%. Texas refuses to put an exact percentage on what beyond a reasonable doubt means, but I will tell you that generally most lawyers think it's around 99% or so of certainty that you're guilty of an offense before they can convict you. So it's a really hard burden to meet in the state of Texas. Coming on down the line, I'm not going to talk about clear and convincing and preponderance, but they're somewhere in the middle, 50 to 75% or so. What we're going to talk about today is reasonable suspicion and probable cause, because that's what you hear the most of. Reasonable suspicion is the easiest burden of proof that the officers have to have. Again, there's no percentage, but 10 to 20%-ish of certainty that you've done something wrong for an officer in the state of Texas to either detain you or to ask you questions or to do something else. Probable cause is a little higher than that. It's closer to 25-30%, and usually you have to have probable cause to be arrested. So again, 20 to 30% likelihood certainty that you've done something wrong or you've done something the officer thinks that you've done to meet that burden of proof. So it's not a lot. It's not a lot. But once you are detained or arrested, for a jury to convict you, it's a lot higher burden of proof. But this is what we're going to talk about today. So starting off with cars. When can the police pull you over? This is our low burden of proof, reasonable suspicion. And situations where you're speeding, of course, and this is, everybody knows that, if you're speeding, if you are a minor traffic violation, like you run a stop sign, you kind of blow through a stop sign real slowly, if your inspection sticker, registration stickers are expired, of course, they can pull you over for that, go up to you in your car and talk to you. Can they order you out of your car? A lot of people get this wrong. Yes, they can. They can absolutely order you out of your car in any situation under the guise of officer safety. So even if you're just being pulled over for speeding, even if they haven't told you they smell marijuana, they can still ask you to get out of their car. Now that doesn't mean they can search your car, but they can still ask you to get out of your car. Can they pat you down? Not always. The officers, again, must have reasonable suspicion that you have a weapon on you. Now this isn't drugs. It's a weapon. And so there's a lot of different case law in Texas that have come out over the years. A bulge in your pocket, is that enough to give officers reasonable suspicion? It can be if there's other circumstances, like you acting a little nervous. Okay? If you have marijuana in your pocket, you're probably going to act, unless you're super cool, calm, and collected, you're going to probably act a little bit nervous. That alone is enough to give the officers reasonable suspicion to pat you down. So just keep that in mind. What if they ask to search your car? The ask must be clear. All right. I think the percentage is like 72% of all searches of cars in Texas are consented to. Now, you guys are above the curve here. You're smart enough to not consent if you've got marijuana in your car. But a lot of people don't realize that. They think that if an officer asks to search their car, they have to let them. Officers will sometimes, and we see this all the time in cases, they'll say things like, oh, you mind if I take a look around? And that's not a clear ask, right? That's just sort of like a, kind of a suggestion. But a lot of people don't realize that officer is asking to search my car. So what you should do is, if you're not sure if the officer is asking to search or not, you tell the officer, listen, are you asking me to search my car? And then make them say, yes, I'm asking to search your car. Then you can say no. Yeah, 72% of pre-arrest searches in Texas are based on consent. And you absolutely do have the right to refuse. Now, what if the officer says, hey, driver, I smell marijuana. I want to search your car. At that point, you're in Texas, you're pretty much screwed. They're going to be able to search your car, and most conservative Texas judges, most judges in general in Texas, are going to uphold that search based on smell of marijuana alone. How long can an officer hold me? Now, this one gets a little trickier for the officers, because if the officer's waiting around, let's say they're even looking for a search, trying to get a search warrant. But if you've been sitting there for a couple of hours along the side of the road, and the officer still hasn't done anything, maybe he's waiting for backup, what have you, depends on how long you wait. But there are situations under Texas law where there have been illegal arrests and detentions because you've been held too long. So what you should do is if you are being held, the officer hasn't told you if you're under arrest, you're just sitting there, you ask the officer, am I under arrest or am I free to go? At that point, it triggers the officer, I've got a smart driver here, I've got a person who knows the law here, this person may file charges against me, file a civil claim against me for false arrest if I don't get this process moving. So ask the officer, am I under arrest or am I free to go? And again, there's no real time frame, but if it's been a couple of hours, it's very reasonable for you to ask that. Really just an hour in my opinion. Again, without probable cause, so reasonable suspicion, they've stopped you, okay? But they don't have probable cause yet, it hasn't reached that next level, they can only hold you for so long. And again, I just said it. So now we're going to talk about, briefly, searches and seizures of your homes. Now, when can the police enter my home? If they have a search warrant, of course they can absolutely come in to search your home. So the officers already had probable cause, they've already sought a search warrant, they've come to your door, they knocked on your door, they say, hey, homeowner, I've got a search warrant, you got to let them in. If they have an arrest warrant, if you are harboring someone in your house, or if you are a person who has a warrant out for your arrest, they can absolutely come in to your house, whether or not you want them to or not. Now, what about the situation where I think one of our other speakers said they're walking around an apartment complex, they're going to the guy across from you, and they smell marijuana coming from your window or your door, okay? They cannot come into your home without a search warrant unless there's another circumstance alongside the smell of marijuana. So they smell marijuana, they knock on your door, you greet them, they say, I smell marijuana, okay? They can't just come in unless there's another circumstance. What they have to do at that point is they have to seek a search warrant to go into your house. At that point, you call your lawyer, for sure. So what are some exigent circumstances that are going on here? Furtive movements, we talked about that earlier, and that's really not defined in Texas, but it's like moving around, a lot of noise, you're not answering the door. That can be under Texas, because again, you're in a conservative state, that can be enough to justify the officers coming in without a warrant. A new case that's come out this last year, the presence of a child in a home is enough to allow an officer to come in. So if they smell marijuana plus a child in the home, that is enough for an officer to come in. Now this case was interesting. It was an actual case where the search of the home was not upheld. And what happened in that case is that a CPS had gone earlier to the home. CPS had met with the family, with the child, and CPS worker smelled marijuana. Okay, what the CPS worker did, they called the cops. When the cops got there, the kids were no longer in the home. The officers came up. The officers said, well, we're searching the home because we understand there's marijuana in here and there's kids in the house. At that time, there wasn't. And so it was, and of course they found the marijuana and they arrested the homeowners. That was not upheld because of the fact that the officers themselves did not see the kids and smell the marijuana. Now, this is the new hot topic with lawyers in the criminal defense world right now, is searches and seizures of cell phones. And why does this impact you guys? Well, our phones are our lives, right? You guys, if you have a smartphone, you keep your calendar in there. You probably keep, a lot of you have your bank account information in there. You may have medical, health-related things in there, notes, pictures of loved ones. I've read cases where there's people who have sexually explicit photos of a loved one in there, and photos of your family, and intimate details about our lives. Okay, so pretty much our phones are an extension of ourselves these days. And if you lose your phone, you know how dramatic that can be, right? So what happens when the police want to search through your cell phone? Because it's happening all over the place in Texas now. Right now, under the law, cell phones are considered containers. And this is nationwide. This isn't just Texas. But cell phones are considered containers. And just like any other container, a little box that you might keep something in, or a little bag, or a purse, or a briefcase, if you are arrested, or if officers feel they have probable cause to look through it, that there's something in there, they smell marijuana or what have you, if officers believe that there is something that will lead them to a crime, they can look through your cell phone. If you're pulled over, you got your phone on your lap, you're pulled over, but you're not arrested, the officers must have probable cause to look in your phone. Okay? So the officers must think, I've got a suspected drug dealer here. I saw him on the phone, and he was calling someone, and he threw his phone down when he got off. Maybe enough probable cause for them to look through your phone without a warrant. If they pull you over for speeding, and they just want to look at your phone, they can't do that without a warrant. If you're arrested in Texas, officers can look through your phone without a warrant. So in Texas, in most situations where it's more than just a basic traffic stop, the officers can look through your cell phone. Now, things are very likely going to change in the state of Texas and across the nation pretty soon. We've got 2 cases that have already gone before the United States Supreme Court, and both of these cases are, if either one of them is upheld, it's going to shake the foundation of officer searches of cell phones. Now, the U.S. v. Riley case was a California case. The defendant was pulled over for expired tags on his car. The officers decided to search through his cell phone without a warrant. So no warrant. They just said, all right, we pulled you over, you look a little shady, we're going to look through your cell phone and just see what's in there. They found pictures of him throwing gang signs in front of a car that had been shot up a week or 2 before, right? So because of those pictures they found in this guy's cell phone that they just happened to look at, they took that to a jury trial. The guy was convicted. So all that after a simple stop where the officers felt like there was something a little more to it. And by the way, they didn't have a warrant to look through the cell phone. So what does that mean for you? If you have pictures, let's say of you smoking with a buddy, and that picture, that buddy of yours is a known drug dealer, or somebody who has a warrant out against them. If there's a way they can tie you to a certain location and a certain person, the officers can use that evidence against you to seek conviction. So right now, until we get some new laws, be very careful what you keep on your cell phones. Pictures, text messages saying, I'm going to be by to make a pickup soon. Things like that, emails even, can be looked through. Put you at a lot of risk right now. The Worry case is a little bit different facts. It's out of Massachusetts. Worry was arrested for suspected drug dealing. So officers already had suspicion that this guy was dealing drugs. They searched his cell phone. They pulled it out. They looked through it. This was not a smartphone. It was just a little basic, one of the flip phones. Inside of that, they found an address that took them to a house of his, and they found all kinds of drugs and guns there. And he was ended up getting convicted of 2 drugs and firearms counts, and at that point, all of the evidence that they found was based off of what was in that phone. So if the evidence in the phone was not valid, then that case could be thrown out. So what the arguments that the defense attorneys are making here is that there's so much information in cell phones, what I talked about earlier, your medical records, pictures of family, checking and savings accounts. There's so much information in those phones that it is much too intrusive for officers to be in your phones, looking at your phones. So that's the argument. It's like, how far can officers go? It's more than just looking in somebody's purse or a wallet or a briefcase or a little box. It's a lot more than that. And so we're going to see what the Supreme Court says. The end of June is when that is going to come down. So we're going to be looking for that very closely. Just to kind of summarize what I went over today, and again, this is probably basic for a lot of you, but I want to just make sure it's crystal clear. In Texas, the smell of marijuana, if you're in your car, means if the officer wants to search it, the search is probably going to be upheld. So keep that in mind. Homes, smell is not enough to justify a warrantless search. If they got a warrant, they could come in. But furtive movements or presence of children can justify the officers coming in your house. Smartphones, again, we just talked about that. So we'll look for that at the end of June, and I'm really excited to see what comes down there. My website's got, we'll have the latest on these cases that are coming down. Love to have you guys, keep up with me on Facebook and keep up with the law and what's happening. Thank you.